Hello everybody and welcome back to our YouTube channel. This is Shireen Kapoor. I'm a Canadian immigration lawyer, and if you are new on this channel, you will find a lot of information, authentic information about moving to Canada, as well as pros and cons of everything, all the programs that we do. Now, Canadian immigration is a very sensitive topic, I would say, wherein everybody is giving you information on how to move to Canada, but less people tell you the options of what are your chances of refusal. Now, you have to keep this in mind that immigration is a very subjective and a very person-oriented program. Each programs, each type of criteria, each eligibility, everybody, it's different for everybody. You cannot apply the same principle for you as your colleague or maybe your friend, family, or somebody. Anybody above 22 is an independent profile in Canada. So we need to be very sure of the kind of refusal rates and what are your options in case you have a refusal. And my today's video is going to discuss all the options that you have as a layman, as a person applying, as an applicant applying to Canada, and what are the options that we are going to discuss. Our first is redetermination, second is a reapplication, and third is an appeal. And fourth is a judicial review. So I'm going to tell you for which criteria your profile fits and which is the most important thing you need to consider before choosing one of the options. Now, the first option is the redetermination option. In what cases, as a lawyer, I recommend that you go for redetermination. See, usually you will get a refusal from Canada, be it a work permit, be it a study permit, or be it a visit visa, or be it even sometime permanent residency. Your refusal will state some standard grounds. So those standard grounds are basically generated by the automatic system that Canadian immigration operates on, which is called the Chinook system. Chinook is the AI-based system, which now the Canadian immigration has increased rapidly, and especially some of the countries they have on their list. Now, if your refusal is very standard, like for example, some of the common grounds is that your temporary stay is not it is not in line with your, it's not consistent with what you want to do in Canada. You have family ties which are very weak outside Canada, your country of habitual residence if you're applying from a place of temporary residence. So these are some of the common grounds, and that will the reasons they will state in your refusal letter. But remember, the refusal letter is only your AI generated letter, whereas your refusal real reasons the officer makes on your file is in the GCMS notes, which people order on their own or through your counsel or consultant. You can order that. It's a $5 fee that you apply on refusal, and once you get the notes on the file, the officer notes on the file, then is the next step that you need to decide. But in most cases, wherein from the prima facie, from the first letter of refusal, you are able to make out that no, I gave a certain document. For example, if it's about a fine, the reason is that you're not financially stable. For example, now you say, no, I gave a document of my employment, I had good finances, everything was there. Now I need to know what is the real reason. So one option that you have as per IRCC is to send your application for a redetermination, which is not going to be a very stringent lens to be applied to it. But only thing that the officer is going to see is that procedural fairness was given to you. So redetermination is not going to check everything, the whole of your application. The file usually goes to a same or a different officer working on your file, but because they will have notes on the central system, they will know how you operate. Now, for example, if you are convinced that all your documents were in line with the kind of application you are going to give, be it visit, study, work, whatever the rejection may be, the application may be, you were kind of sure, you can send the application to the same country via web form. You can raise a web form. Also, you can send the email to the program manager of that country, and you can send it via email to the particular country embassy where you're applying, Islamabad, Abu Dhabi, New Delhi, wherever. So you just need to send them a redetermination letter, maybe a counsel letter or something, in which you state the grounds of how your case had met everything, and maybe the refusal was not in your hands and it was beyond the documentation, and you just don't understand the reason of refusal and you're very surprised, you're taken aback. That is when I say, okay, redetermination is a free option, so maybe why not try it. Usually the response time from the embassy would be 30 to 40 days. The parameters to check redetermination is not very high. They are only going to see, okay, if they miss something on the file, if the officer made some notes which are not actually recommended or which were not applicable to your case, or somehow the AI mixed it, because refusals nowadays can be AI based also. So you need to be sure that you have the GCMS notes in place for you. But remember, redetermination should not be, it should not be reliant on GCMS, because GCMS can take 40 days to come in. So maybe you can apply redetermination within a span of 30 days. So there is the second option, which usually I recommended, and I will tell you in what cases, is the reapplication filing of your case. Now, what happens sometimes, I get cases in which I see that earlier the documents would not suffice for the kind of application we were trying to submit. Now, for example, maybe you were trying to submit a work permit application, but you did not show home ties, which is a very integral part of any temporary resident visa that you're applying to Canada. Now, home ties could include lifestyle documents, country documents, maybe even, they could have your affidavits from your family, your properties, your gold, everything. Basically, all your assets and liabilities in a particular country is your home ties. Even your mortgage is a home tie. So there are many things that you can, attach to the file in terms of showing home ties. And that, if that, I feel, after reviewing the GCMS notes, is a ground of which could have been covered with proper documentation, because remember, Canada is all about documents. They are never going to have a face-to-face interview in rarest of rare cases, but usually it's all about documentation. So now in some cases I feel, no, maybe you did not do a proper job on your file and your documents were not enough. In that cases, I say, don't waste your time in terms of going to redetermination or appeal. Just go for reapplication. It is also a myth that reapplication will be have the same result as the first application. No, sometimes people come to us with 5-6 refusals also, but they still get approved in the 7th case, 8th case. We have had cases of people who have got 16 rejections as well. So you can imagine the kind of reapplication is successful. Your applications are not linked to each other. The only thing is the GCMS notes, which is very important, of why your application was rejected, true reason to find why your application was rejected, and sometimes documentation and proper formatting of those documents can help you get the case approved. Now let's discuss the people inside Canada. If they get a certain kind of refusal and they are within the Canadian land and they have a refusal and they want to, maybe it was an extension of visit visa, maybe it was a PGWP application, maybe whatever it was inside Canada. Remember, the third one to trigger, for the appeal to trigger, you need to be inside Canada, and there is a limitation period for each application that is refused, within which you can appeal the decision. Now, when I say appeal, then obviously you will not be obviously handy with the court process and everything, and you would sometimes need a counsel. Most of the cases you will need a counsel, and the appeal will give you the chance to represent your case in front of a higher bench, a higher judicial court, in which you are able to say, okay, I submitted everything, and the grounds, maybe the grounds that you refused my case was not right, or maybe sometimes it's just an error of law, and that error of law can be covered through appeal. So it is your particular choice, your particular decision, that you want to go for reapplication in that case, or you want to go for appeal. Sometimes people are within a particular time frame and they don't want to be out of status, and hence they file appeal. So there are different cases of why you are going for appeal. It also depends on the reason of your first application rejection. So be sure to take advice of a proper counsel of that case in your particular case, of if appeal is a good option for you or not. Now, if you're outside Canada and you think your rejection has been unreasonable, even if you're outside Canada, mostly of course, people getting refusals are outside Canada, less are inside Canada. So those people don't have the option of appeal, but those people directly have the option of approaching the federal court and knocking their doors with the thing called judicial review, which Canadian immigration system offers. And in that, you are directly going to the federal court, asking the federal court to see if there has been a procedural fairness error in your case. Procedural fairness is very important, and throughout, as a counsel, I can tell you, we have been taught many cases in which we have been able to understand the jurisprudence of this procedural fairness and substantive law. So what happens is, sometimes you are not given an opportunity even to be heard. For example, now visa officer does not find your documents suffice to explain a particular point, or he thinks maybe your job offer is not genuine, or some document of your employment is not genuine, education is not genuine. So those kind of visa officers are supposed to give you a notice of maybe 14 days, 30 days, or PFL letter. Now, in usual cases, you will get a PFL letter wherein you will get a chance to explain yourself. But in some cases, the visa officers miss and give direct rejection. Now, that is a very good case in which you have not been given an opportunity to be heard. To be heard is the key here. And if you have not been given an opportunity to be heard or represent your case, that is an error of law. That can be taken directly up to federal court, and usually there is a reverse of decision of misrep. There are reverses of decision in judicial review. The success rate is quite high if you go through proper counsel and lawyers and you are able to navigate your case and you're able to explain your and represent your case properly in the federal court. So that is also an option which is going directly to the court, and you can take expert advice of a counsel there. So, as terms, maybe the approval rates for Canada is touchwood very high for ACE as well as for in general approval rate is good if you have submitted your application properly. But there is also chances of refusal, and I always give this caveat to clients that remember that everything is in our hands, but the 5% luck factor is also there in your hands, because you never know what visa officer is thinking, what they are looking at, what particular documents are time lapse or something, some problem is there. So that 5% chance you always have to keep in mind, not just for Canada, be it any kind of global mobility decision you are taking. So because end of the day, it's a government and an admin department. So now, after explaining you all the 4 points, it is up to you what kind of options you want to route yourself to. Maybe in some cases, my judgment says that reassessment is better, that is redetermination. In some cases, I feel no, maybe reapplication is better. In some cases, judicial review is better. Within Canada, for people within Canada, appeal is an alternate option. As well as they can then, if the appeal is rejected, they can still go to judicial review. So they have two options when you are inside Canada, more options. So it is completely up to you, but I do recommend take the expert advice of a consultant, a regulated consultant or a lawyer on file, and then get the proper notes on file. Always remember, notes on file is the most important thing to start what next steps you have to take. Submitting the same application also makes no sense. So if you have any question, query, concern, get in touch with us. Our contact details are in the description box. Thank you, and thank you for watching. And for more such content, subscribe to our channel.